Great weekend. Hey, Miss Becky, how you doing, man?
He does not want that appointment, but we have to continue because they're also here. Attorney said, told us that he didn't want that appointment.
It's serious bodily injury.
He's still up.
I probably scratched him off the
Serious
jail.
bodily injury.
Check with the letter of the judge.
Is it? Maybe that's
He may still be in general basement.
Okay.
If it was just, I think, if it was just bodily injury, there's you know, like
Talking about
maybe
weight
misdemeanor
over.
trial.
No.
Serious bodily injury. But it's, you know, it's in the
We're gonna do y'all in about 5 minutes, okay?
there's like under 80 or 10, A and B.
Wilson. Chris. Miss Wilson.
Hold on, what if this is what about you?
One else coming in late. The late.
All right. Mr. Reagan, Mr. Bowling, I think you have several motions. Let me see those motions. Mr. Brown, what are you doing here? I mean, it's so rare that I see you up here. I was just wondering.
You might have thought I was defending.
No, I didn't think that.
Thank you for asking.
All right.
Well, please, we'd like to be heard first before we start arguing these motions.
All right.
I think the one probably that prior bad acts needs to be addressed. I think the chambers like it was before.
Okay, that's fine.
Just the nature of it. The other two, as far as the motion to reconsider the court's ruling on the expert, I'm not sure of anything in the rules of criminal procedure that allow motions to reconsider. This case was litigated, briefed, court ruled, Court of Appeals denied Rule 10 on the court's ruling. I think the finality of that is nothing new. And you don't just keep relitigating, taking court's time, the state's time, to relitigate the same issue that was just litigated less than a month ago. So the state's asking not to hear this motion to reconsider. Nothing new, there's no reason, there's no procedure of the law is to go back and relitigate everything you previously litigated. So we're asking not to relitigate that issue. As to the discovery motion, that was also litigated. Mr. Perez made a motion in open court, and it was granted as far as discovery. Now, the order they attached to their pleading was later amended to correctly state the court's ruling. That misstated the court's ruling, and it was later amended by the court to properly reflect the discovery requirements on the state, which the state would argue obviously it complies with every bit of discovery we can possibly provide under the law. It was gathered by the search warrant, gathered by the court order, that's the victim's phone records, and Mr. Vandenburg's records. So the state has totally complied there. The motion has previously been determined by the court also, so to relitigate, especially at this late day today before we start the trial, we don't think it's appropriate.
Okay. Well, respond.
Your Honor, please, as it relates to our, and thank the court for letting us be heard, Your Honor, please, in regards to our motion to compel the production of the electronic digital media, we attached for this court's convenience a previously entered order dated October the 21st, 2014, and in that order it states, on agreed upon date and time between the defendants shall be allowed to view, copy, and photograph any and all evidence collected in this matter that is being held by the Metropolitan Police Department and any and all evidence held by the District Attorney General's office. Our experts, Logic Force, and Mr. Gavin Patrick that is here this morning that will provide testimony to this court, they're willing to work under these strict guidelines. We had asked the state to allow us to produce or to obtain a copy of that, and we didn't get a response until a few days later saying that they would not allow us to copy that. And I think Mr. Patrick would say that the technology exists, that you hook it up to a device, you copy it, and we come pick it up. And Mr. Patrick's here, and I would like to call him as a witness, and I would like to be heard on that. He is our forensic expert analysis, and he can provide the information to the court why this information is critically important to their job and to what they're to do to provide Mr. Vandenburg with defense as it relates to their expert services, Judge. So we would ask the court to indulge us and allow.
Well, what I want to do, I want to get another response from the state before we put on any witness, but in addition to that, would you tell them to be quiet back in the back, please? Okay, Joan, I'm a little confused about this. What's happening with this?
Your Honor, I also share your confusion in that Mr. Boland's written motion states with no particularity exactly what items he is referring to, much less does it state any cause or legal basis for his request to be granted. What he is in effect requesting of this court is equivalent to that of a search warrant, which would require him with particularity to state what the item is that he's asking this court to review a probable cause basis to have another search of digital media done. We have at least 15 to 20 cell phones, multiple laptops. He has everything that belongs to Mr. Vandenburg. That is what they have access to. That is Mr. Vandenburg's property. They can have access to it. Everything else that is digital media that could fall into this lump sum category belongs to someone else. The police have searched those items for evidence related to this incident. It was a very specific search warrant that was granted. They searched the items for that evidence. Everything was provided to the state provided it to the defense. The defense is requesting that this court provide all of the digital media, which again, that is not specific. So we're talking about hard drives from laptops, entire cell phones of people that could possibly only be tangentially related to this case. They have given absolutely no cause whatsoever why they would need to do the search related to this crime. That is what is in the written motion. I mean, it is not even allowing the court a basis upon which to grant a claim because they're not providing the court with anything that is required to make this request. Now Mr. Boland has stood up in open court and stated that he has Gavin Patrick here to testify from Logic Force. Well, going back to our previous hearing, they requested this court allow expert testimony after they missed multiple deadlines imposed by this court. They were specific in their argument in that they argued to this court that the only reason they were making the request to have a digital expert was to rebut the testimony of Detective Gish. They were not introducing any new evidence. They were not going to be testifying about any additional analysis. It was only to rebut the testimony of Detective Gish. And Your Honor issued a ruling that was very specific that allowed them to have a digital expert for the purposes of rebutting Detective Gish's testimony. Gavin Patrick was not the person from Logic Force that they actually listed in the Notice of Expert Witness. So again, we have a new name here today. However, their request is ultimately going back to something that should have been done well before December 2015. They are referencing an order in which the defense drafted after a hearing that Your Honor had in October of 2014. That order that the defense drafted was not indicative of Your Honor's actual ruling. It was a broad statement that they can copy any and all evidence. Well, they have copied any and all evidence. They have everything. The state submitted a supplemental order which was specific to Your Honor's actual ruling that was narrowly drafted. It was narrow and specific that after your hearing of the defense's request for this very same thing, that they would only be entitled to information related to the victim's text messages, but that was only after Your Honor did an in-camera review to determine the relevancy. And Your Honor determined that they could review the messages from 3 days before and 3 days after, and that was it. That no other request was relevant to this case. Again, this is October 2014, and yet the day before the trial is supposed to start, they've come in and they want to begin the process of making a request, and they haven't completed step one, much less gone through the lengthy process that would be necessary to make this request, but ultimately, it's completely irrelevant. I can't even fathom how they could come up with relevancy to make this request, but the request that they have made is improper. There is no legal basis upon which Your Honor should grant it, and the same request that Your Honor deny it.
All right, Mr. Bowling. So specifically, what are you asking for at this juncture?
Your Honor, please, in response to the state suggesting that I did not give them indication what we were asking for, I spelled it out very clearly in the correspondence that was attached as an exhibit to our order. And I would like to point out to the court, Judge, that this goes to the heart of rebuttal. The rules of discovery require that they allow us to photograph, copy, view each and every item of evidence they plan on introducing at their case in chief. These cell phone devices house evidence that they intend to use at their case in chief.
And you're saying that you have not received that information?
We received a report. We can't verify that report. We have pieces of paper with thumbnail images. And it's not hard to duplicate that, and I'm not a forensic expert, I'm not even going to try to be. It's not hard to duplicate that. We need the raw data. We need the metadata. We need to know when it's sent, when it's time-stamped. We need that information. Our experts need that information. I laid it out just to answer your question. This should include forensic or mirror images of any digital media, all extractions from any mobile devices, mobile device backups, and any log files related to the creation of forensic images and extractions. And I even spell out, we'll provide Detective Gish with whatever digital storage device he needs to store this data. Again, Judge, I'm no expert. I've got an expert, a member of Logic Force, and I believe the court has approved Logic Force and that firm as our experts, and they are rebuttal experts, but to rebut, they have to have the evidence. I believe that Rule 16 is very clear and that we should have access to this. The state will stand up here and they'll lead this court to believe that, well, we got all of the alleged victims' information, that we received these reports, but they say in the same voice, we limited to what we gave you. And oh, by the way, the cell phone is mysteriously gone now. It doesn't exist. So we do not have what we need for our experts to prepare a defense for Mr. Vandenburg as it relates to rebuttal evidence. We've got reports. We've got, I think it came out at the last trial, there was some chicken dinner thumbnail post on some report that we got, and I think Detective Gish said that shouldn't have been there. We need the raw data. And they can plug it into a system, they can hit copy, they can hit extract, whatever they need to hit to make that. And I would like Mr. Patrick to be heard if the court wants to inquire as to how long that process would take. They're working around the clock, and we need this evidence to prepare a defense for Mr. Vandenburg. And Your Honor, please, if the court recalls, back in Chambers in December, I had inquired to come and actually look at these devices so that we can verify the data. And we were told no. This isn't the first time we've made this request. We were told no then, we've made it a second time, we've been told now, the court ordered it to be done, and we're asking the court to order that those forensic images, mirror copies, be made available to Mr. Vandenburg so that we can accurately prepare this case for defense as our rebuttal witnesses.
All right, and State, you're saying that you have provided this information.
Your Honor, the state has provided all of the evidence. Mr. Boland, again, is now trying to further explain and narrow his request, and which it's still unclear to me, but I would assume that he is now referring to the extraction reports related to only the phones where images were found of Mr. McKenzie, Mr. Banks, or actually Mr. McKenzie's phone didn't have any images on it, so I guess he doesn't want that one, just Mr. Banks and Mr. Batey's phone. Again, this is completely non-specific, and my argument would be tailored to each individual device. However, the general issue is that when they were here with their late notice requesting an expert witness, Detective Gish was here. He was available to get on the stand and explain exactly why this would be a burden and why this would cause a delay at this late hour. However, on that date, when he was here and available to testify several weeks ago, when we could have addressed this issue, even it being extremely late on that date, Mr. Boland stood up to this court and he said they were only calling Logic Force to rebut something that Detective Gish said. He said that they were not asking for any data to be provided, and they were not asking Logic Force to do any additional analysis. He is now coming to the court and asking that the court order that the forensic data that Detective Gish viewed be provided to the defense for their forensic expert, who again is a new person even today, to do a forensic analysis on it. I think it's clear to the court, without even hearing from Mr. Patrick, that this is not only incredibly late in timeliness of filing, it is against this court's previous order and ruling. Your Honor has never ordered that this digital extraction information be provided to their forensic expert because they never complied with the court's ruling. They did not comply with the rules requesting notice of expert witness. They have never made this request to the court. They're coming in at the last minute asking it can be done. Detective Gish is not available today, but if he were here, he would be able to testify to the court and explain that even if Your Honor were to consider this, it wouldn't be possible to have all of this done. Mr. Boland has admitted that he doesn't know anything about digital forensics, and it is a more complicated process than what he says. This is inappropriate. They haven't even stated a basis by which this would have any relation to their defense whatsoever. The images that were found on Mr. Vandenburg's phone they have had since October 2014. They have been able to analyze all that information, but they haven't provided a report, which is required by the rules, to even be able to call Logic Force to testify about that. They told this court they were only calling him in rebuttal to rebut something that Detective Gish testified to in his process of his computer forensic analysis. And again, this is an inappropriate and improper request that they have given absolutely no legal basis for.
Okay, last time.
Judge, I believe Your Honor was clear when this court put down an order that we should be allowed to copy any and all evidence, not nitpick any and all evidence, not to limit our ability to prepare a defense. Yes, we have been given Mr. Vandenburg's data on a housing device, whatever that may be, a forensic copy. But the state isn't just, sorry Judge, the state just isn't using Mr. Vandenburg's digitally stored information. This court knows what they're using. And we are asking that those housing devices, that those digital storage media devices that house that information that they are going to use at trial in this case, that be provided, not the information, but the actual forensic data, so that I never suggested to this court that Logic Force was not going to do their own evaluation. I mean, that's material. Why would I hire them? Why would we retain them to just look at a report, look at reports and what it says? Well, I mean, that's not what they're there for. They're there to evaluate and to prepare defense team so that we can adequately represent Mr. Vandenburg as rebuttal. If Detective Gish were to testify as to one thing and we don't have the information to suggest it may be different, it may be the same, there may be more to it, we can't get that information from his report because he's going to tell it from his report.
I mean, what information could you get from this digital information that it's not, I mean, that you won't be able to have as in rebuttal to Detective Gish's testimony?
The only thing that we have is the reports that Detective Gish has given us. It would be like saying, we've analyzed this bullet that pierced the skin of this individual, but Mr. Bolin, we're not going to let you have that bullet analyzed by your own independent crime scene reconstructionist expert. That's what they're asking this court to do, limit our ability to have those items of evidence evaluated to independently determine whether it's accurate or not. And I can't express that to the court exactly what they would be looking for. I call it raw data and metadata, but that's why Mr. Patrick's here, and that's why I've got him here to explain to the court what he needs, what Logic Force needs to accurately do their job as defense rebuttal expert witnesses in evaluating the digital information that's been provided in this case. That's what Mr. Patrick is here for, and he can elaborate that to the court. And Judge, it would have been premature for me to call Detective Gish to the stand when Your Honor hadn't even ruled on our motion, that they filed a motion to quash our experts, or to exclude. We filed a response to that. So it would have been premature for me to call Detective Gish and ask him how to make all these things up when Your Honor hadn't even ruled on that yet. The minute that this honorable court ruled our expert testimony could be used as rebuttal, which the court ruled, Logic Force began working, and they began working exactly based on what this court, and the next words out of their mouth is, where's this data, where's these other forensic copies? All that we were able to get from the Jacobs group was Mr. Vandenburg's. That's what prompted me to immediately send a letter and request it. They need it for their
And you're looking for data from whom?
From any digital media storage device in which the item of evidence they plan on introducing at trial. That's what Rule 16 suggests. So if it's a text message from ABC phone, we want the forensic copy of ABC phone.
Well, I did previously rule that there were certain text messages that could not be used or viewed. I limited the number of text messages that could be viewed. I know that.
As to the alleged victim, I believe.
Correct.
Yeah.
Correct.
And we can't get a copy of the alleged victim's phone because it doesn't exist. I'm talking about the other individuals, Your Honor.
Yeah, but I thought, I mean, my recollection, and I may be wrong, was that most of this information was already provided. I think that Mr. Perez was involved in that aspect of it.
It's only been provided in paper form. I'm looking for the raw data, the digital data unit that houses the information from which it comes from. The text message came from a phone. We need an extraction of the forensic copy of that phone. They download that. There's software that does that, just like they did on Mr. Vandenburg's phone, and we got a copy of that digital media. So if there's a text message, again, I'm referring to an ABC phone, or from Banks' phone, or from McKenzie's phone, or from Beatty's phone, that the state intends to introduce at trial, we want I'm using the word forensic copy, a bit-by-bit mirror image copy, forensic copy, whatever they're referred to, of that digital storage device from where that evidence has come from.
Okay. Well, I understand what you're asking for, so I'll make a ruling on that. I don't. Go ahead.
If I may, submit a copy of the amended order that Your Honor issued, clarifying the previous discovery order. It was filed on October 29, 2014. I referenced it during the argument. I was just asked that it be used with it.
All right, that's fine. And I'll go over this as well. All right, well, I'll take a chance to read this. I don't think I need the testimony of the gentleman from Logic Force. I understand what the issue is. So, and I believe I understand what he would get up here and say, basically, is that he cannot or they cannot properly rebut certain information unless they see the raw data to make a determination as to what the raw data actually says. Anyway, let's move on to this other matter. I will, although I think Joan Thurman, I know Joan Thurman was correct that we don't have anything in our rules that speak to motions to reconsider, but I still will allow you to be heard on this matter with respect to, well, no, we need to do that in chambers with regard to prior bad acts. But and well, the motion to reconsider, this is what I was looking for, the motion to reconsider excluding expert testimony. You can be heard on that.
No, please, briefly, just as a housekeeping matter, at this point in time, we're not asking to be heard on our motion to reconsider the prior bad acts ruling. We're not going to withdraw that motion at this point in time, but we're still in the process.
Say that again.
We are not in a position to hear that motion to reconsider the prior bad acts. We're still investigating some evidence that we've obtained over the weekend, and at this point in time.
Well, at what time would you want to have that motion heard?
Maybe possibly Friday. If we want to have it heard at all, we may withdraw that motion. And I think the rules allow on prior bad acts that even if it's during trial, there could be a jury out hearing. But at this point in time,
I do.
But at this point in time, we're not ready to go forward with that, Judge.
All right.
So they subpoenaed a lady who just worked, they subpoenaed her boyfriend who knew nothing about the case and wasn't even her boyfriend. They've been here all morning. I don't know the basis of why they're here to testify based on the law, but anyway, they've basically been inconvenienced and brought them before here and now not to go forward. If they haven't, I don't know. I guess we can address that. I'm not their lawyer, but she did contact our office over the weekend and explain how this was such a hardship on her, and she.
Yeah, well, that's a matter I think you mentioned earlier. We need to take up in chambers, and so I can do that.
They've been released. They're our witnesses. They've been released. I've been with them since 6:30 this morning, Judge.
Okay, all right, but you're withdrawing that motion for now. You're striking the motion for now.
I'm striking the motion to be heard from today's docket.
All right. Now, what about your motion to reconsider the order excluding expert testimony?
Judge, as to our motion to reconsider the expert testimony of Sid Alexander, Judge, we have provided a report, a letter to this court and to the state as to what Mr. Sid Alexander was retained and in what respect he was retained. For all intents and purposes of today, Judge, we are asking this court to reconsider allowing Dr. Alexander to be able to testify should Mr. Vandenburg's sobriety be called into question. If someone were to get on that stand and say, not acting out of the ordinary, he was fine, had 3 drinks, 4 drinks, 22 drinks, 31 drinks. If his sobriety is called into question on that stand, then we have a right, a constitutional right, to rebut that evidence. And that's why we're asking this court is that we don't feel like, Judge, under Rule 16, if we weren't going to call Dr. Sid Alexander in our case in chief, then we are not to provide a report. And that's laid out in the case that I provided, in which the Court of Appeals struck down an order from the court requiring that the report of their expert be provided, and the court struck that down, saying it's too broad. If they were going to call that expert as their case in chief, report had to be provided. Our defense team decided that when this expert was hired, we immediately gave notice I'll do candor to this court. I don't think we had to give notice. I was the one saying we didn't have to give notice because for rebuttal purposes is why Dr. Sid Alexander has been retained. And if he is being called as a rebuttal expert witness to rebut the testimony of Dr. Kenneth Furslew or to rebut the testimony of someone else that will speak on the intoxication or lack thereof of intoxication of Mr. Vandenburg, then we do not believe that we had to give any notice respectfully to this honorable court or to the state if he's being considered as a rebuttal expert witness. And that's why he's been retained, and we respectfully ask this court to reconsider allowing Dr. Sid Alexander to, at a minimum, be called to rebut the state's proof when those things are called into question. We still believe that the order, that's the rebuttal argument, but we still believe that the court took a drastic measure in not allowing us to call Dr. Sid Alexander at our case in chief. There was no bad faith on our part. We believe the state's been on notice. They heard it during the first trial. They've heard it all along. We respectfully ask the court to reconsider allowing Dr. Sid Alexander to testify at our case in chief. However, we understand that the court set a deadline. The deadline came and went. And, you know, if that results in ineffective assistance of counsel and the case is tried a third time, it's tried a third time. We're asking this court to allow that evidence to come in at its case in chief, but at a minimum to allow us to call Dr. Sid Alexander as a rebuttal witness. Because I can sit here to this court today and suggest that if Mr. Vandenburg's defense is prohibited by his counsel's ineffective assistance, then this case will be tried again. We believe that that there is no bad faith on this defense team's part in giving notice of Dr. Sid Alexander. They've been on notice since 2014 of the intoxication and the testimony that would be derived from an expert as it relates to Mr. Vandenburg. So we're respectfully asking this court to allow it to come in as case in chief, but at a minimum as a rebuttal judge.
All right, who for the state?
Please, I've been doing this a long time. I've never heard the argument that a defense expert can be called without notice. And if it's in rebuttal of our rebuttal, maybe that could happen if we put on a rebuttal expert to rebut their testimony. But he's not a rebuttal expert. He's just like every expert in all the cases you see where experts have determined whether they can be admissible or not. And the previous ruling of this court was absolutely correct and fairly administrative justice. The state is entitled to a fair trial. This victim is entitled constitutionally to fairness in the court. Counsel for this defendant has totally ignored the orders of this court, totally ignored the rules of criminal procedure, and I think to gain a tactical advantage. To allow this testimony deprives the state, one, of our ability to hire a rebuttal expert, of our ability, which we have an absolute right to do, to have Mr. Vandenburg evaluated. It really negates any ability we have to research and conduct meaningful cross-examination. They said they provided, and I think we got it Tuesday of last week, 1 week before we go to trial, this doctor's report. I won't even dignify and call it a report. I don't know if it's with the court, but it's an unsigned.
I saw it this morning.
Unsigned letter, so I wouldn't call it a report even. It doesn't talk about what data he considered, doesn't have a CV with it, doesn't talk about any test he did. We don't know, so we couldn't cross-examine. We previously cited Reed and Mays, establishing the state has a right to a fair trial, establishing the court has the right to control your discovery with your orders. Now, they've thrown out Dr. Stalinsky, the great Dr. Stalinsky, who I was really looking forward to cross-examining, but unfortunately, they withdrew their notice. Remember the history of Dr. Stalinsky. We continued a trial once, I think, as part of Dr. Stalinsky. She was sick. She couldn't get a report done. Then her husband was in the hospital. Couldn't get a report. We finally get a report. The state made a file to exclude her testimony and also to evaluate Mr. Vandenburg. And they withdraw Dr. Stalinsky. That was in 2014. They withdrew notice of Dr. Stalinsky. never to be heard from again. So they're trying to say that gave the state notice. Well, we had the trial, there was no mental expert in the trial. So then we had the case set for trial 2 more times, no notice of mental health expert. And I think before Mr. Reagan's heart issue, which may be 10 days before the trial was to be scheduled, no notice of mental health expert. And then after it gets continued and we have the severance, then 5 weeks before we get just a name, which does the state absolutely no good. On December 1st, the deadline, they could have said, well, we're going to call Dr. Stilinski, here's her report, if they were going to rely on that. They didn't give notice to the state at all. 5 months passed before they even gave a name. And now what's it been, 6.5 months before we get a half-page unsigned letter 1 week before the trial. And you know, what if we had gotten this letter December 1st, 2015? The state would immediately file to exclude his testimony under case law, which I think is clear in the state of Tennessee. And if the court had disagreed with us on the case law, we would have had an opportunity to do a Rule 9 appeal prior to the trial without having to continue the trial. We would have had every opportunity to appeal the court's ruling. And I would just cite to the court, I know you're familiar with Hall. We've been down that road. State versus Faulkner, 154 Southwest 3rd 48, Tennessee Supreme Court, 2005, which I think talks about Hall and more distinguishes it a little bit. Then you get to State versus Farrell, 227 3rd 372. It's also, I think, the Supreme Court. And what's been established in the case law is it's not diminished capacity, it's not impairment of function. It has to be a total lack of capacity, that you're unable to form the mens rea required by the law, that you have a total lack of capacity to do that. Now, I have 2 cases that recently came out in the past year prior to Your Honor, that since Your Honor even addressed this issue before. One is the Sergio Wilson. I'll provide the court a copy. Finish a copy. And the other one is State of Tennessee versus Michael Bonsky. The Bonsky case just came out at the end of April, so it's really a recent case.
One goes to defense.
State versus Sergio Wilson is actually my case. It's a capital case. In that particular case, Dr. Lippman, who Your Honor is familiar with, testified. There was another very well qualified expert that testified before Judge Blackburn. The state filed a motion to exclude their testimony because it was dealing with drugs and alcohol. It was dealing with them saying it was impaired function. It would have harmed the reasoning of this individual in this first-degree murder case. And again, obviously, in a death penalty case, there's even heightened due process issues to deal with in a death penalty case. Judge Blackburn had a hearing on his 2 experts and excluded them, saying that they did not say that this defendant totally lacked the capacity to form the intent in that particular case of premeditation. Rule 9 was taken, granted by the court, since it was a death penalty case, and the Court of Appeals affirmed Judge Blackburn and said, yes, that is the law. These experts did not testify. There was no capacity at all to form the mental status required in first-degree murder. The Bonsky case is the same. It's also a murder case. In that case, they raised the drug and alcohol, the same type of testimony, exactly that he would have been impaired. It would have affected his ability, his state of mind they're talking about. And obviously, in that particular case, the court denied the expert based on Hall, Farrell, Faulkner, all the line of cases, saying it's not diminished capacity. Our Supreme Court has said, and our Court of Appeals have said clearly, this is not something you bring a mental health expert in every day. And you know, if you look at the rules on expert witnesses, you can call them only if it substantially assists the jury, even if qualified. You know, if you read this, where it's now saying Mr. Vandenburg had 27 plus drinks, 17 shots during this day, I mean, the village idiot would know we'd be impaired. I mean, obviously every juror would know that that would impair your functioning somewhat. But this is simply not even if the court found they complied with discovery, this would not be admissible evidence based on the case law, especially the most two recent cases coming out of the Court of Appeals, which directly address alcohol and drugs as being a factor, not a mental illness. And if you look at Dr. Alexander's statement, it's right down the line with those people: exhibited poor judgment, altered perception of environment, greater susceptibility to influence, poor impulse control, diminished brain function. Well, that's exactly what these experts were testifying about, and they were excluded. The state feels very strongly, and also they talked about Brown and having a right to put on defense. And the case they cited had to do with a photograph. There's a big difference in a photograph and a mental health expert with the rights that come along from the state of Tennessee. And even the U.S. Supreme Court chambers are talking about Brown, says the right to present a defense is not without limits. The Supreme Court has observed that the accused, as is required of the state, must comply with established rules of procedure and evidence. They have not complied with either one in this case, Your Honor, please. And to allow this testimony is fundamentally unfair to the state, and it would not promote fairness in administration of justice in this case. And we're not worried about ineffective assistance of counsel. In fact, all you had to do is threaten the court, and we have no rules. We just stand up and say, if you don't do this, we're going to be ineffective. I don't think that's the case, and the state can deal with that. There's also a second problem of ineffective counsel, which I think the video can strongly overcome. But anyway, the state clearly objects to this testimony or whatever Dr. Alexander, based on his unsigned letter.
All right. Your motion, final word.
Just briefly, Judge. Just the representation that I'm threatening the court with ineffective, I'm not. The court said we missed the deadline. I'm not threatening the court. We know what can come about a lawyer missing deadlines or a defense team. Judge, in the state, and I'm going to get this name, Valvahara case that I cited in my motion to reconsider, if the court will indulge me just for 1 second. While the state of Tennessee is entitled to inspect and copy or photograph any results or reports of physical or mental examinations, this right is not without limitations. The state's right to discovery is limited to results and reports which are within the possession or control of the defendant, and the defendant, and this is emphasis added, the defendant intends to introduce as evidence in chief at trial, or were prepared by a witness whom the defendant intends to call at trial when the results or reports relate to his testimony. In this case, the court had put down an order.
Wait a minute. Cite that case you're
No,
talking
sorry,
about.
Your Honor, please. 735 Southwest 2nd, 837.
And the name of the case?
State v. Valvahara, Vilvarajah, and that's cited in our original motion, our response to their motion to exclude. It's cited.
All right.
And the court had put down an order, and the court went on to say, in the case, the appellant is faced with the dilemma of whether Dr. Hillary Linder, his personal psychiatrist, should be called as a defense witness. If the appellant intends to call Dr. Linder as a witness and his reports relate to the testimony he is to give at trial, the appellant must comply with the discovery order entered by the trial court. Conversely, if after reviewing Dr. Linder's reports, the appellant makes a decision not to call, or reports do not relate to the scope of the testimony, the appellant is not required to comply with the discovery order. And the court goes on to say that it's an overbroad order if you don't plan on introducing that testimony at your, the rule says for itself, at your case in chief. And Dr. Furslew has been a witness identified on their witness list, and he's going to talk about the effects of alcohol. And he's on their witness list for this trial. And if he were to get up there and say something, then we have a constitutional right, Mr. Vandenburg has a constitutional right to rebut that testimony. Does it say we have to give prior notice? Because we're rebutting the testimony of a state's witness that they called. If someone says the car was black and someone's going to say it's blue, that's a rebuttal witness. And we are asking this court to reconsider its ruling in that I don't know, I've not seen, I've not heard, I've not read in the transcript that any notice of any expert has been withdrawn by anybody. Mr. Thurman will stand up here and say that we withdraw our notice of expert testimony. I don't see it. It's not in the record. Just because we may not have, well, we weren't original trial counsel, but just because Dr. Stalinsky may not have been called at original trial does not mean that that expert was withdrawn or that notice of expert. And I'm not going to rehash what I've already argued before this honorable court previously. We believe that there was no bad faith on our part. The state has been on notice of the effects of alcohol on Mr. Batey, Mr. Vandenburg, and everybody involved ever since the inception of this case. If at any point in time after that original notice of expert regarding the mental condition of Mr. Vandenburg, the state had the opportunity since 2014 to seek a mental health evaluation should they have asked. And should they have asked, I'm sure this court would oblige them. They didn't ask.
All right, thank you. Well, what I'm going to do is I'm going to look at these cases real quick, take about 15 minutes, and then come back and let you know. In the meantime, I do want to see Joan Miller and Ms. Hurd right now.
All right. We're in a 15-minute recess.
I actually thought back to a meeting I had with the Court of Criminal Appeals judge just a couple of weeks ago. We were having dinner at end of court, and he was saying, you know, he said, sometimes I sit around, I think about issues for a month or two before I decide it, unlike at the trial court level where you have really a matter of minutes to decide an issue. And he said, I often wonder about that. Well, what I will do is, I'm going to take more than just a few minutes. I'm going to take the evening to think this issue through and let both sides know tomorrow morning with regard to this expert testimony. You know, as I said, I read the case law and I understand what that says. I just need to process it. And I will let both sides know regarding that tomorrow. And so I think that concludes matters for today. All right? No, I'm not. No. Okay, Mr. Hastings, you have an announcement?
Brief announcement, Judge. On page 9 of your docket, Renee Freeman, she's on for